if you already have a deportation order against you from the past, then ICE and Border Patrol could either subject you to expedited removal proceedings, or they can quote-unquote reinstate your prior removal. And those processes, expedited removal, reinstatement of removal, are nasty, and they are the way to deport somebody without giving them the right to see a judge. And it's only for people who are crossing the border now, or within the last 14 days for expedited removal, or who already have a prior deportation order against them. Okay? And so let's break that out a little bit more. All right? And if you're just joining me, hello, welcome. I'm Otis Landerholm. And please send me your questions if you have any questions. I love that you're here with me. Okay? So let me break that out a little bit more. Okay? What is expedited removal? What is expedited removal? Basically, it's a way for Border Patrol, for Customs and Border Patrol, and sometimes even ICE can do this too, right? To deport a person, all right, in just a few hours. Not 2 years, 3 years, 5 years of a process with hearings in front of a judge. They literally can do it in just a couple of hours if someone is entering the U.S. without authorization, and then the person doesn't have the right to a hearing in court. We call it expedited removal proceedings. Okay? That's expedited removal. So then what is reinstatement of removal? Reinstatement of removal is if you were already deported in the past, ICE and also Border Patrol, they don't need to give you a hearing in front of a judge. They can just reinstate the prior order that was signed against you, even if that prior order was an expedited removal order. Okay? But if you don't have those things, if you don't have an expedited removal order, and if you're not subject to reinstatement of removal, and if you're here in the U.S., then you have the right to fight your case in court. Get it? Okay? This is fundamental. This is basics. This is absolutely important. If you are in the United States, and if you are undocumented, and if you do not have some record against you, a deportation order against you, then you have the right to fight your case in court. You have the right to have a lawyer go to court with you and make arguments and to present applications and to submit evidence and to argue that the judge should allow you to stay in the United States. All right? This is so important. And I just want you to know that you have that right. You have that right. Don't give up on that right. That right gives thousands, hundreds of thousands of people hope to be able to win their case. All right? And it doesn't mean just because you have that right that you're automatically going to win. It does not mean that. But it means at least you've got a chance to argue something. At least you've got the ability to fight the fight. Okay? All right. And so there's this question that often comes up. Hey, 10 years ago, I was caught crossing the border. I'm not sure if it was a deportation or I'm not sure what exactly happened. There's lots of people walking around that don't really know whether or not they were deported in the past. Therefore, they don't know whether or not they would have the right to fight their case in court if immigration were to find them today. And so what do you do about that? You run FOIAs, all right? And FOIA, the FOIA process, it stands for the Freedom of Information Act. And if you're our client, we've done this for you, all right? With a few exceptions. If you're our client in immigration court, we've done this for you, okay? If you aren't sure whether you have a deportation order or not. If you're not sure whether or not you qualify for something or not, let's run your FOIAs. Let's run and get a request and review and look at and do an analysis of everything that immigration has in your record, in your file. And let's look carefully at the documents. Let's see whether or not you're subject to reinstatement of removal. Let's see whether or not you were ever ordered expeditiously removed in the past. Or let's see if you would have that right to fight your case in court if immigration were to ever come to look for you. You got to know this stuff. All right? You got to know this stuff. So if you are in that situation, or if you're not sure what happened in the past, hey, give us a call. The FOIA process, it starts with a call. Starts with a consultation. Deportation Defense, same thing. Starts with a phone call. Or even a text message now. If you want to send us a text message, by all means, please do. We'd love to do that. So, all right, send me your questions. That's all I had for like the legal topic for today. So we've got plenty of time. Send me your questions. Any questions you got, I'll take them. Okay? And we're live. It's the 7th of June, 2022. And I really appreciate it. Kamba, hello on Instagram. Lacey, hello on Instagram. Welcome. Thank you so much for being here. Hello to everybody on TikTok and Facebook and YouTube. Thank you all so much. All right. I do see a question here. Is it Mayton? Mayton, hello. Welcome. Thank you for asking your question. You say, hello, lawyer. How many times can I use my combo card? Also, I'm from Mexico. Can I travel to other countries besides Mexico, like Colombia? Okay, Mayton, good question. Thank you for asking that. If you have a combo card, all right, where they granted you work authorization and also advanced parole, we call that. The advanced parole document, depending on when you applied for advanced parole, it typically allows you for multiple entries. On the I-131, which is the form to apply for advanced parole, there are boxes to check, and you can say one-time travel or multiple entries. So if you have a combo card, if you filled it out the way anybody normally would fill it out, you check the box for multiple entries, all right? And typically, Border Patrol, they'll see that, they'll run your records, they'll make sure that you don't have any new arrests, no problems when you were outside the United States, and then they'll say, okay, and they'll allow you to use that card to come into the U.S. The thing about advanced parole is that it's dependent on some other process, okay? So it might be dependent on a pending application for a green card, for example. So as long as that green card doesn't get denied while you're out, or as long as there's no record against you filed somewhere while you are out of the U.S., you should be fine to re-enter the U.S. to continue with your process. And so that's the way I would answer that question. The best advice is to talk to your lawyer first before you travel, just to confirm that your combo card was filled out properly and that there's no issues with it and that your case is still ongoing and pending, right? Maybe you got it from TPS. Maybe you got it from something else. I mean, if you're a citizen of Mexico, it's probably a pending application for a green card. But that's my advice. I'm sticking to it. All right? Talk to a lawyer first before you travel, and my guess is you'd be fine. And the question of, oh, can I go to a different country in addition to Mexico? Just be prepared to explain it. All right? Border Patrol can ask you questions about that on your re-entry, so just be prepared to explain it. Again, when you apply for an advanced parole document on the form I-131, you list what countries you're planning on visiting. All right? And so, and we've had clients do that, and travel to other countries besides their home country, not have problems coming back into the U.S. You should be okay. All right? There you have it. There you have it. What other questions are out there? I'll wait for, I'll wait for, I don't know. I'll wait for like a minute. If you have any other questions, send them over. We'd love to have you send them over. I see some new folks joining us on Instagram. Montek, hello. James, sorry. Hello, not to be confused with the Middle Eastern organization, Hamas, I believe that's in Lebanon. James, thank you for joining me on Instagram. Hello, welcome. Everybody, thank you all so much. I think that's the story for today. And so that's great. I really appreciate your tuning in today for another episode of Deportation Defense Live. If you still have a question and I haven't answered it, hey, please send it in. I'd love to answer it. If this was useful, please, as always, please subscribe to our channel, especially in YouTube, and click the notifications bell so that you can get notification whenever we update or whenever we upload additional videos with additional updates and immigration news. And if you have an immigration case, hey, please give us a call. We are here to help, okay? There's also some news about the 3- and 10-year bar. There's a case that's been filed. It was filed in Washington State, and it's an exciting piece of news. I'm going to do a whole video about it. They're actually litigating about an argument that my firm has made from the beginning, all right? And basically what they're saying is that if you trigger a 3 or a 10-year bar, but then lawfully re-enter the U.S. on a visa, for example, that you can spend the 3 or 10 years here in the U.S. And it's actually true, right? It's not, USCIS has a misinterpretation of it, but the law has nowhere in the law does it say you have to spend those 3 or 10 years outside the U.S. And so I'm really grateful for the Northwest Immigrants' Rights Project for bringing that case in Washington State. I'm excited about it. I'll do a video training about it. So if you've seen the news about that, hey, subscribe to our channel on YouTube and you'll get more information about it. Okay? So Mr. Tusk, I see your question there. How long is an I-130 taking to be approved? Let me get you the answer to that right here on the spot. I love it. So let's see. Current processing times, USCIS. And let's see if USCIS is going to cooperate with me. I-130. We'll say for a spouse of a U.S. citizen. And it's not allowing me to get the processing times for some reason. So I'll change it. I'll say permanent resident filing for a spouse or child that's not a spouse of a U.S. citizen. Permanent resident filing for a spouse or child, right now it's saying 24.5 months at the California Service Center. What you need to do, Mr. Tusk, go to uscis.gov, click on check current case processing times, put in I-130, and put in the service center where your I-130 is located, and then it'll come up, okay? And sometimes their servers are slow and down, and sometimes it doesn't get it. You know, if you have questions or whatever, please feel free to give my office a call, or I have videos about that on YouTube as well. Okay? But it's there. You should be able to find it, uscis.gov. But right now it's saying about 2 years to get an I-130 approved. Okay? Which is slower than what I've been experiencing in our office. We've had some I-130s recently approved that it seems to me that USCIS is picking up again. There are old applications that are still taking a long, long time, but it seems like USCIS is starting to adjudicate more cases. There you have it, everybody. All right, that's it for today. I'm going to switch and do this in Spanish, so if you want to join the Spanish version of this, stay tuned and check out our live link in just a few moments. And thank you all so much. Have a wonderful rest of your day. I'm Otis Landerholm, Landerholm Immigration, A.P.C, where we fight for your American dream, and I'll see you next week on our next episode of Deportation Defense